Appellate District of Ohio, the Honorable Pierre Bergman presiding, is now in session.
Good morning, everyone. Welcome to the First District Court of Appeals. We have 3 cases to be argued this morning. When I call the case name, if counsel could introduce yourself and indicate your readiness to proceed. First case is State v. Revere.
Laura Peters on behalf of the appellant, Mr. Revere, ready to proceed.
Okay.
Amber Daniel on behalf of the appellee, City of Cincinnati, ready to proceed.
Okay, thank you. State v. Richards.
Laura Peters on behalf
Double
of the
duty
appellant,
today, great.
ready to proceed. I'm sorry, I've got the state of Ohio ready to proceed.
Okay, thank you. And then Crutcher v. Oncology Hematology.
John Allison on behalf of the appellant, ready to proceed.
Okay.
Peter O'Shea on behalf of Oncology.
Okay, great. So when the appellant approaches, just let me know how much time you want for rebuttal. And with our light system, green means go, yellow means you have a minute left, and red means you're done. Ms. Peters. And how much time would you like for rebuttal?
3 minutes, Your Honor. May it please the court, Ms. Daniel. My name is Laura Peters, and I'm here on behalf of the appellant, Brian Revere. In this case, Mr. Revere pled guilty to an OVI offense, and the issue in this matter, well, first was the driver's license suspension, which the state graciously conceded as error. So we'll be focusing in on the second assignment of error, which is the restitution. Now, we're not disputing that there was damage caused to Ms. Foreman's house. The issue in this case, however, is whether the trial court correctly interpreted RC 4511-19 G7 and whether or not Ms. Foreman actually suffered any economic damage. First, the trial court seems to have read 4511.19 G7 as a limit in all OVI cases of $5,000 of restitution. However, the first sentence, the inquiry for the trial court, is whether or not there was proof of financial responsibility. And this...
Can I ask you a question, ma'am, on that? Are you asking us to remand for a restitution hearing? Because it indicates that your client had insurance, I think with Progressive, or whoever it was, and was going to make a restitution to the prosecuting witness for the damages she had sustained. I know her insurance company had seemingly paid for those damages. So it's unclear to me whether or not your client, despite the fact that he apparently had a letter saying that they would make good on the restitution, there was some issue whether that he really had insurance or whether they really were going to do that, at least in my mind. So what are you asking us to do here?
First, I would ask just to straight vacate their award of restitution.
Okay. All right.
And the alternative, if you think that the evidence is unclear about the amount of insurance, then it should be remanded for a new restitution hearing in the alternative.
Well, some of the damages had not been fixed yet at the time of the hearing, right? So she had estimates that said, like, it's going to cost roughly this much, but they had not actually been remediated at that point.
Correct. That is correct, Your Honor.
So what is a court supposed to do with that in terms of making a potential award of restitution at a time before the damages have been fixed, when it's like construction, which sometimes takes a long time? Like, what's the court supposed to do in that circumstance?
In that circumstance, and the statute has made clear that the burden to prove the amount of restitution is on the victim, the prosecuting witness. So if the prosecuting witness can't come to court with a concrete amount, then the court can't grant restitution, and it has to be left as a civil matter between the parties.
So when you say concrete amount, you're saying that coming to court with an estimate is not enough?
In some cases, an estimate would be enough, but in this case, what we have is she provided estimates, but we also have testimony that she has insurance from Allstate that covered the first $9,000, roughly $9,000 of damages, and that there was a remaining $21,000 to $22,000 damage that was estimated. However, my client, and it is not questioned in the record because the ticket indicated my client provided proof of insurance. There was several of the hearings there was indicated that my client had showed proof of
Let me ask you this, ma'am. There's proof of insurance and proof of insurance, and I know the limits in Ohio are very low. I think it's still 12.5, which is, at least in my, is it 25, whatever it is. It's ridiculously low. But there was no evidence that whatever the insurance he had would cover the damages to the house.
Well, we had the estimate, so we already know that her insurance company, according to her testimony on page 66, paid for the first $9,000, and we also know he had insurance. The state minimum, as you by statute, is $25,000 for property damage.
Right.
So the remaining property damage that was estimated was $21,000 to $22,000. Well, that means and Progressive is his insurance company, I believe, committed to pay that. So what we have is we don't have any proof that Ms. Foreman was suffering any economic damage.
So you're basically advocating some sort of burden shifting, that once he comes forward with that letter as proof that he has insurance, then kind of the burden shifts to her to say, well, that's all well and good, but it's not going to cover this, or Progressive has refused one of the claims or something like that. Like, it would be on her to establish that. Is that what you're saying?
Not exactly, Your Honor, because under the statute, the restitution statute, 2929.28, the burden is on the victim by preponderance of the evidence. So she has the initial burden to prove what her economic damage is.
But going back to my question, though, so you said that an estimate sometimes could be enough. So if the person did not have insurance or something, are you saying an estimate's not enough when the person has insurance? Because I'm trying to figure out how a victim, normally it's out of pocket, like what the victim's out of pocket. Now we know what her damages are, there's this estimate. When would an estimate be enough for the judge to order restitution on the estimate?
Well, if there was no insurance involved, and or if we know that we knew what his amount of insurance was and her estimate exceeded his amount of insurance.
So if there was no insurance involved, then would the statute come into play?
Well, okay,
and then he's
yes.
capped at $5,000?
Correct. Yes. See, the issue is also the statute. The first sentence asks the trial court to determine whether there's financial responsibility, proof of financial responsibility. We have that in this case. So the second sentence says if there's no proof of financial responsibility, then the trial court may award restitution but not to exceed $5,000. So trial counsel below was arguing you can't even order restitution because there was proof of financial responsibility under the more specific provision of 4511.19 G7. So first argument is restitution couldn't be awarded in this case under the more specific statute that govern restitution for OVI cases specifically. The second issue is then, well, even if you agree with the trial court's interpretation that, well, really the statute is limiting the restitution award to $5,000, our argument is there was no proof that the victim had economic damage in the amount of $5,000, and that's because that Mr. Revere had insurance. And though we don't know the specific amount, we do know the statutory minimum of $25,000, and her estimate was below that. So there wasn't any proof of economic damage, therefore the trial court should not have awarded restitution.
So if her estimate was above that, then would it have been appropriate for the trial court to order the difference in restitution?
Taking 4511 G7 aside.
Well, yeah, if you had insurance.
In a normal case, like if there was, when it's just if it's a theft case and there's no insurance, and there was an estimate, this is the cost of how to replace this piece of equipment, then yes, the estimate would be sufficient and the defendant could be ordered to pay restitution in that amount. But in this case, we have proof of insurance And we also have an estimate that doesn't go above the proof of insurance.
But I think what you're saying, though, is even if the estimate exceeded the insurance amount, the victim would not be entitled to restitution under your interpretation of the statute. Am I understanding that right?
4511.19 G7, yeah.
Okay.
But if you disagree with that, then the secondary argument is the insurance
Understood.
issue.
Right.
If the panel has no further questions, I'll reserve the remainder of my time.
Okay, thank you.
Thank you.
Ms. Daniel?
May it please the court, Ms. Peters. My name is Amber Daniel, and I'm here for the city of Cincinnati today. Your Honors, what is before us today is two assignments of error, one of which, the first assignment of error, we have conceded. The second assignment of error is based on the restitution amount. So in our interpretation, the restitution amount, the defendant might have had insurance, but she was not made whole by this insurance.
It wasn't that he might have had insurance. He did have insurance, and he produced proof of that. And if you all disagreed with that and said, oh, this is a bogus letter, or, Progressive was really denying the charges, isn't it incumbent upon you to establish that?
Yes, Your Honor. So he did have insurance, but there's an amount that has not been paid at this point, $21,000 and $21,185 that she has estimates for that have not been paid.
But this gets back to my initial question to Ms. Peters. I mean, this is construction work that needs to be done at the house, which sometimes takes a long time to get effectuated. And so the fact that she's got the estimate and you've got the letter from him saying, I have insurance, like, how do we know that she's not going to get made whole here? And how do we know that this $5,000 isn't a windfall to her?
So based on our interpretations and the case that we provided as well, the money, since it would be provided to her, it would be different than the other, because in this case that we provided, the money was provided to the prosecuting witness and not to the insurance company. So we don't think that it would be a double windfall, because she still has, if there's the $25,000 that has to be paid, or the $25,000 minimum for the insurance, if there's $9,000 that has already been done at this point, there's still $21,000 left. So that's $30,000 worth of damage at this point. So she's still, even if they paid $25,000 worth of damage, there's still $5,000 worth of damage.
But she's not the one that's paid that.
Or his insurance company. So if his insurance company has paid $25,000 worth of damage, there's still going to be $5,000 that she's going to be out.
Ms. Peters, let me ask you, it sounded like Allstate was the prosecuting witness or victim's insurance company, and they said, yeah, we'll take care of fixing the house. Would, at least in my mind, they would be the one that would have a subrogated interest against her, Ms. Peters' client. You understand what I'm saying? If they pay it, somebody has to pay, whether it's Progressive, and if a shortfall comes up, they'll just sue him for the remaining $5,000, right? I mean, that's my understanding of what would happen here.
So it was my understanding when when the victim was spoke to in court, when the questioning went forward with that she was still going to be out that money, that her insurance was only going to pay the $9,000 and she was going to be out the remainder.
Okay. Right.
Was my understanding.
Okay.
Well, out what remainder? Because if Progressive covers everything that she's got an estimate for, what is she out of pocket?
So Progressive, it was my understanding, Progressive was going to be also speaking with her insurance company and paying back the $9,000 as well. Mm-hmm. So if the policy limit was $25,000, they'd pay back the $9,000, and then there would be $21,000, $185 that would still need to be paid. So if they had a policy limit of $25,000, she would still be out.
And so then this runs into Ms. Peters' second argument, which is the interpretation of the statute. And it does seem to be disjunctive, because the first part says, if you do have financial ability to pay or insurance, but then the second part says, if you don't, then the limit is $5,000. So how do we how do we interpret that?
So my interpretation is if the insurance company has paid for it, then we can't make any kind of claim. But if there's still an amount that has not been paid for, then you could have up to $5,000 of damage at that point. Because the goal at the end of the day is to make the victim whole. And in this scenario, the victim would not be made whole. She would still be out a substantial amount of money for something that was no fault of her own with this OBI. So based on...
And I guess, sorry to keep picking at this, but are we speculating on that because we don't really know what was going to happen? I mean, what you just said about that Allstate would get paid some, and then we don't really know whether that's going to happen, do we?
So that is correct. I mean, we don't know 100% what will happen because we don't know how much. I mean, lumber could go up, lumber could go
Right.
down.
Right.
So the estimate could either be higher or lower at the end of the day. So a lot of this is based on speculations of what will happen at the end of the day. So our case that we cited was State v. Burlinger. In State v. Burlinger, there was a theft offense, which I know is not the same as an OVI, but we would be asking to use this as persuasive authority. That in this case there was insurance that did pay some amount, but it did not negate the ability for the prosecuting witness to be able to get money as well, restitution as well, so that they could be made whole. So that is our argument in this scenario, in this case, is that the $5,000 will be making her whole and that she will not be whole if it's just based on the insurance because there's not enough to cover the claims. So if there are no further questions, thank you for your time.
Ms. Peters, you have 5 minutes.
Your Honor, Judge Bergeron, I think you kind of pinpointed the problem in this case is that this is the amount of any economic damage that Mrs. Foreman might suffer is speculative because we know from her testimony that her insurance paid the first $9,000, and we also know from the evidence presented at the restitution hearing that my client's insurance company was going to pay.
The rest of it or the whole thing? Because then there would be a shortfall.
That they committed to incurring the liability. So whatever the liability was, they committed to paying.
So $25,000 worth, and the estimate is almost $30,000.
But when you take into consideration the amount of economic damage, you have to take into consideration all insurance. So we don't know if Allstate's going to be reimbursing Progressive for the $9,000. It's speculative, and the burden is on the prosecuting witness to establish the amount of restitution. And if restitution is up in the air, she is not without remedy. She files a civil suit. What the goal is to make the victim whole, but if we can't do it in this setting, she has another remedy of a civil proceeding. So and the restitution amount has to be based upon something in evidence. The $5,000 amount is rather arbitrary unless you're considering it that the trial court was just imposing what he believed to be the limit, but that was the limit if you are uninsured. And the G7 provision of 4511.19 doesn't actually call for restitution being ordered against a defendant who has shown proof of financial responsibility. Ms. Daniel cited to the Berlinger case, which we believe puts this court in conflict with other districts, as we pointed out in our reply brief, because you do have to take into consideration insurance paid from all sources. And the Berlinger court seemed to say, well, because the victim in that case had insurance and had to pay the premiums, that the defendant shouldn't get the benefit of that. But the statute has made clear that the victim is not entitled to an economic windfall. And that's exactly what happened in the Metro case, is that the victim ended up getting a financial windfall. In this case in Thornton, which was a more recent case, this court seemed to backtrack from that and said, no, we have to take into consideration, it was a Fifth Third Bank had reimbursed the victim for whatever economic damage. So the trial court, when it was pointed out, you can't order restitution to a third party, the trial court ordered it to the victim and said, well, the victim can then pay back the bank, possibly. This court said, no, that's not permissible because the victim has already been made whole. They don't have any economic damages. The award of restitution was vacated. That's what we're asking you to do in this case because there is no proof that Ms. Foreman is going to suffer any economic damage.
We're speculating that she's going to be made whole. And then if she's not made whole, you're saying she can sue civilly.
Well, the proof at trial or that at the restitution hearing was that her insurance paid for the first $9,000 and Mr. Revere submitted proof that his insurance company was committed to pay for whatever liability was incurred. So we're not necessarily speculating that she's going to be suffering any economic damage. That her estimate was 39 has already been paid. The remaining portion was going to be covered by his insurance company. So we would request that you vacate the award of restitution in this case. Thank you.
Thank you, Ms. Peters. Thank you both for your arguments this morning. The case will be submitted. We'll get out of time and independent. Hope you both have a great day. Next case is State versus Richards. Ms. Peters, whenever you're ready, but take your time. Welcome back.
Thank you.
How much time would you like for rebuttal this time?
3 minutes.
3 minutes. Very well.
May it please the court, Ms. Adams. I represent Christopher Richards in this matter. What we have here is Mr. Richards was charged with 2 counts of child endangering. The trial court, there was some confusion by the trial court as to which count went to which child. So so he asked the prosecutor to designate 1 count to one child and 1 count to the other child.
Now, in this case, though, I understand there was this confusion, but the complaints actually say which child's which, right?
It does, but I think by asking the prosecutor to designate which one, it's effectively amending the complaint.
So they just flipped the names.
Essentially,
Okay.
yeah, so that the 5-year-old became the child in the A count, and the 3-year-old was the child in the B count.
Okay.
What the testimony made clear in this case was that the 5-year-old was with the mother in the laundry room. So therefore, Mr. Richards, who was in the apartment, could not have created a substantial risk to the health or safety of that child.
How is it so clear? Because I thought that what came out and what it seemed like the judge believed was that the 5-year-old or the older child was in the apartment. I mean, I thought, and I don't want to use the children's names here, but
5 and 3 is good.
Yeah, but I thought at the end when the prosecutor was electing which was which, it seemed that the judge was clear and which child was in the apartment was the older child.
The prosecutor is the one who initially made that assertion, actually. And that is not part of the evidence. The evidence that we have as to the location of the children solely comes from Ms. Hall.
But also, so the older child, the first initial is C, correct?
Yes.
Okay. I thought that Ms. Hall said when she was talking about who answered the door, she did use a name.
She did
used
not.
the C name.
She did not.
I thought she said like the baby or something.
She said that, yes, Your Honor, that's correct, Judge Bergeron. She said, because she said there was a child in the laundry room who was upset and that she believed that the mother was seizing. So she goes to the apartment, she knocks on the door, and she says her initial testimony was the second child answered the door. And then when when they went to clarify, they're like, well, who was the one answering the door? She responded, the baby. And then at a different point in time, she asked, well, are you familiar with the children? And she goes, I believe C is 5 and P is 4 or 3.
But does it matter though? I mean, you're talking about this is a sufficiency argument, and the name of the child is not an element that the state has to prove, right? They have to prove it was a child. So didn't they meet their burden under the sufficiency?
But the child involved, you have to have a child involved, and the child involved in count A as designated by the prosecutor at trial was the 5-year-old.
Well, let me ask you, does it matter if the child was 5 or 3? There's no question there was a child in that apartment.
But you have to look at the count. He was a...
Well, I think following up on Judge Krause's question,
Right.
does it really matter what the child's name was as long as it was he or she was either 5 or 3?
But I believe it matters which child is in what location. Because obviously, if the 5-year-old is with the mother in the laundry room, she's the one who's assuming the care custody of that child. And
There's no question that whichever child was in there, 5 or 3-year-old, was in the apartment with the dad passed out.
There was a child in the apartment, yes. But
That wasn't contested, was it, ma'am?
I'm
I don't
sorry?
remember that being contested, whether there was even a child in that apartment.
No, it was not contested that there was a child in the apartment, but the point is on the sufficiency, you had to prove that child was, where that 5-year-old child was, and he wasn't with his father.
Well, I guess you said something initially about, is there effectively an amendment to the complaint? I mean, is this a situation where there's a variance and you kind of, I'm trying to understand, like, getting back to the question of, like, was it critical that we know the identity of the child, or was the complaint essentially amended at trial?
If I understand your question, the complaint was in essence amended, and the trial court made clear that he was not going to convict Mr. Richards of the child who was in the laundry room, because that child was with the mother. The fact that the prosecutor unfortunately misled the court as to which child was in which location. Now they even asked defense counsel whether she would agree to this, and she said no. She said, I'm not sure that the evidence is that clear, and if it's not so, and that's the state's burden. So we're talking about this, the state's burden to prove, and the state is elected to make count A the 5-year-old. The 5-year-old was in the laundry room with the mother.
I mean, you're talking, I mean, this is like a variance issue, right? That the evidence at trial varied from the complaint.
But when you have 2 counts and 1 count goes to each child, it's not a variance issue at that point to me.
So if you had one complaint in this case and the complaint put the wrong victim name, would that matter?
As long as there was a recognition of that at trial and they amended the complaint to reflect the correct name.
Okay. Let me ask you, what prejudice, if any, was visited on your client by having the wrong child?
Well, my client was convicted of child endangerment of the 5-year-old, which he wasn't in charge of.
I understand what you're saying. I do, but and again, I go back to the question, what difference does it make? There was no dispute that the child in the apartment with him was his child and was either 3 years old or 5 years old.
Well, and then we get to a second part of the issue, and then which is more under the manifest weight, I would believe, is did my client actually create a substantial risk? Now, the state is relying on the fact that Narcan was administered. However, the testimony in this case, there was no drugs, recovered no drug paraphernalia, no needles, no nothing. And the trial court made the finding, I can't find that he was passed out due to illicit drug use. So what does that leave us with? A medical emergency?
Well, the judge said an altered state, right? Some altered state. Yeah, that my recollection is the guy's between the bed and the wall. The lady shakes him, nothing happens. She calls the police. He shakes the guy. He's still asleep. Sits him up. He's still asleep. Paramedics come. They Narcan him, and then he kind of wakes up.
Not right. The testimony was that it didn't really have much effect on him.
Right.
That he did not become responsive, and there's actually no testimony that he did become responsive before he was taken to the hospital. So I don't see how you can rule out a medical emergency, which he would not have been. Then he wouldn't have created this substantial risk to the child. This is something that would have happened to him, not that he was reckless about creating a substantial risk. And because the evidence isn't clear as to why my client was passed out. So whether or not he was on the bed partially or in between the wall and the bed, because no one testified he was actually on the floor, that can be a result of a medical emergency. He could have hit his head. He could have had a seizure.
May I ask you this question, ma'am? And I know it came into evidence that you talked a little bit about the 3-year-old or the 5-year-old in the laundry room. The mother was passed out in the laundry room as well. Is that something the judge can consider when trying to determine exactly what's going on here? I mean, are you saying that they could have had 2 medical emergencies, the same thing, one passed out in the laundry room and the other one up in the bedroom, and they can't wake them up? I mean, is that something the judge could consider?
I don't know. The judge didn't make that.
That was in
part of his
evidence.
finding.
That was in evidence, though, right?
Yes, it was in evidence, and it was also in evidence that Ms. Hall testified she thought that the mother was having a seizure.
Okay.
Whether or not that was the
You said
case.
a double seizure.
Well, it could have been something totally. It might not have been a seizure from Mr. Richards. It could have been something else. The point is what is the evidence that Mr. Richards created a substantial risk? Now, if the trial court can't find that this was a result of illegal drug use or any other affirmative action on the part of Mr. Richards, then he should not have been convicted of child endangering.
So just to understand, if you're saying it wasn't proven, but if it had been proven that he ingested some sort of drug that caused him to become unresponsive, then that would be child endangerment.
I believe there's case law that supports that.
Okay.
Yes, Your Honor.
But what you're saying is that in this particular case, because there was no evidence of drug paraphernalia.
Or drugs.
Or
needles,
drugs.
Or anything.
Okay. But I understand the judge did mention that at some point, but it sounded to me when I read the transcript like he was inferring that in fact there was some kind of overdose that occurred here, because he talks about altered state, he talks about his weird positioning on the bed, and I thought that the Narcan did wake him up.
The trial court made that finding, but that finding is contrary to the testimony of Officer Teeple.
But I thought he woke up and got agitated.
No, he never actually testified my client woke up or became conscious. He said after the Narcan was initially administered, it had little effect on him. That he was being monitored for some time, and he became increasingly agitated.
But he was in a passed out state where they even tried to sit him up to try to wake him up, and he wouldn't wake up. And then I thought after the Narcan was administered, he did wake up because he got agitated.
No, there's no testimony that he actually became conscious. Actually, the testimony is the contrary.
So when did he become agitated?
I think his body movement became more agitated, but not necessarily that he was.
So you're saying the record shows that your client remained unconscious the entire time and never woke up after the Narcan was administered?
I'm saying the record isn't clear.
Oh.
Because the officer testified, if Narcan is going to be used on an opiate overdose, there's an immediate response from the defendant or from the person who used the drugs. In this case, he says that didn't happen, that there was a slow response that Mr. Richards was monitored for some time and gradually became more agitated to the extent that they did a sedative. He never testifies. There's no testimony that my client ever became conscious.
But yet they gave him a sedative when he was unconscious?
That's the testimony is yes. Is that they gave him a sedative, but there was no testimony. That
I'll
he
go back
had
now and
away.
read it again.
Should have given him some adrenaline.
I will, if there is any time remaining.
Yes, you've got your rebuttal time. Thank you, Ms. Peters. Is that it?
Good morning, may it please the court, Ms. Peters. First of all, with regard to the children, I think we're putting a lot of weight on a witness's characterization of a small child as a baby. Regardless, I mean, she said it was a small child. I think we're kind of parsing things.
Well, but I think the fundamental problem is the court convicted him of endangering the wrong child, right?
Correct.
So what do we do with that?
Well, no, I believe that the trial court's explanation matched, and I take exception with the characterization that the prosecutor misled anyone here. I think that, again, these are both small children. They're within I don't know the sizes.
I don't know if anyone was saying misled. I think there was confusion because the complaints say the names. And then the prosecutor tells the judge that the complaints don't say the names and then flips them.
I believe they say the initials.
No, they say the names.
They say the names.
Yeah, I have them right here.
Maybe I was confused.
They have the full children's names on each complaint. And then she tells the judge that they don't. And then the judge just said, well, which child's which you need to elect.
Okay.
Right? So, I mean, I don't think anyone's saying that the prosecutor purposely tried to mislead anybody. I just think the prosecutor was confused.
Well, and I think, again, here, the important matter is that they're both small children. And when the mother is seen with the first child, that's a small child. And the witness who's testifying here, we don't know that she's necessarily intimately familiar with which child is which age, what size they are, compared to one another. We could have some 3-year-olds maybe similar in size to a 5-year-old. I don't think that, quite honestly, that it matters, and there isn't any prejudice. These are both his children. And again, all of the testimony regarding the entire circumstance of this entire event, I think, come into play, and the trial court's finding parses that out. And I think that the fact that it was ultimately the 5-year-old in the apartment, it doesn't matter. He still had that duty of care, and I don't think there's any prejudice based on which child.
I think Ms. Peters would say, well, the prejudice is the 5-year-old was in the apartment and you convicted him for endangering the 3-year-old, which he did not do. So that gets back to my initial question. So what do we do with the fact that there was an error by the court in terms of which one he was convicted under? Do we just say it doesn't matter? Is there a doctrine through which we look at that?
Well, I think under the circumstances, it doesn't matter. If perhaps one of these...
Tell me why legally. Tell me why it doesn't matter legally.
Well, and I think if we want to imply that there was an amendment to the complaint to do what... I mean, I think it's clear from the record here, the intent was to only find him guilty of the offense involving the child in the apartment. And quite honestly, I don't know, aside from putting these small children on the stand, how to avoid that confusion. Again, and it was my understanding, I thought all references were with initials, and that gets confusing myself. I don't believe the children's names, with regard to in the testimony, I thought that involved the initials, but distinguishing them between their ages, and again, I think a lot of the confusion, or they put a lot of emphasis on the fact that the eyewitness who initially found the mother and the other child referred to the other child in the apartment as a baby, and I don't think that we need to put that much weight on that.
Well, but is there other testimony that would have identified who the child was in the apartment?
No, aside from the eyewitness.
Well, I mean, that's the problem then. Like, if you're saying the evidence established that a certain child was in that apartment, and you're saying disregard that testimony, then what is the evidence that shows who was in the apartment?
Well, the testimony that was put forth involved both children, and like what was set forth before. That's what initially led her to go to the apartment. She knows that this is a family. She knows they have 2 small children. She sees the incident in the laundry room and then proceeds to the apartment. So given those circumstances, and I believe the trial court in making his finding set forth, his intent to have him just found guilty of one of the children. And I think that's clear. And I don't think that should be overturned by this court just because of the confusion with regard to which child is which. They're both his children.
I have a question. Did Mr. Richards tailor his defense to a specific child and say, no, Judge, you got the wrong child, it's this one? Or
No, that's something that's come up on appeal.
Did it affect his defense in any way?
I don't believe so. Again, it may be different if one wasn't his child, but for all intents and purposes, they were both his children. With regard to his state, I think it is significant that the fact that Narcan was to what degree it revived him, I don't know that matters necessarily, but it just all played into the weight that went forth in the evidence that the trial court relied on with regard to his
But the
his
trial court, what was the precise finding by the trial court as to what, if anything, he was under the influence of?
There was nothing specific that he was, under. He looked at the circumstances of how the individual was found. Again, the testimony, I don't believe that the trial court, he did say that he was awakened by Narcan. So all of those factors were what the trial court considered, and I think the trial court's free to give those the weight that he did. In this instance,
And there was no specific evidence. I mean, clearly there was no drug paraphernalia. I think he was taken to the hospital. There were no medical records, nothing like that. It just sounds like the trial court inferred that because you're right. I think the trial court did find that he was woken by Narcan, and just the way he was lying on the bed. I guess it seems to me like he inferred that he was under the influence or he had taken something.
Right, and I believe that's circumstantial evidence, all of those indications. And there was a bit of testimony, and I think they went back and forth with whether or not the officer who testified had the enough knowledge to testify about the effects of Narcan and how it's specifically geared toward opiate use, but that certainly was set forth in the record. So again, this is a weight issue, and I think that the trial court did not abuse its discretion in applying that weight that was appropriate in this case. If there's no further questions, I will submit.
Thank you. Ms. Peters, you have 3 minutes.
So, Ms. Peters, just to understand your argument on which child was which, that's a sufficiency argument, and then your argument on the inferences that the trial court made is your manifest weight argument. Okay.
That's correct, Your Honor. So, with regard to Officer Teeple's testimony, it's on page 27 of the transcript where he says that the paramedics administered Narcan. They only got a little bit of response, but the defendant was still not alert. So the trial court's finding that the Narcan woke the defendant up is contradicted by Officer Teeple's testimony that he was not alert. Narcan didn't have the effect on him, and so the officer's testimony is if Narcan is used for opioid overdose, if it's administered, they wake up. That's not what happened in this case. And the trial court then makes the specific finding. I can't find that there was any illicit drug use here. So that doesn't correlate then with his convicting because then what did Mr. Richards do to create a substantial risk of harm to the child in the apartment? The positioning on the bed is to me a rather neutral finding, because that could be a result of him rolling. He was asleep or on the bed. He had suffered some heart attack. I don't know. And he could have rolled over, or he could have gotten up, gotten dizzy. I have vertigo, so when I first stand up, I can get dizzy, and then it caused him to fall, and he hit his head, and he was and the fact that two people couldn't wake him up. Again, it's sort of neutral. It doesn't say that he created the situation, that he voluntarily did something to create a substantial risk to his child. And so with that, if there's no other questions,
Great.
we ask
Thank you.
you to reverse. Thank you.
Thank you both for your arguments this morning. The case will be submitted. We'll get a timely written decision. We both have a great day. All right, the next case is Crutcher versus Oncology Hematology. Mr. Allison, when you're ready.
Thank you.
And
I reserve 3 minutes, please, Your Honor.
You may.
May it please the court, Mr. O'Shea. My name's John Allison on behalf of Appellant Tom Crutcher. There's a lot here, so I'm going to try to hit what I think are the highlights in terms of the arguments. I want to start with the defendant's or the appellee's first cross assignment of error. And their argument there is that Mr. Crutcher isn't owed anything because to date he has not executed a subordination agreement. The issue there is that the appellee first made that argument in halfway through briefing summary judgment. I think it occurred to them that they could try to make that argument, but the reality is if you look at the operating agreement, the signing of a subordination agreement is only a precondition if it is being requested. And the sequence of events is in late 2015, there was a request for a...
it was being requested because there was, I guess, negotiation over what was included in the subordination agreement.
Right, Your Honor. So there was...
how could it not be requested?
I'm sorry?
How could it not be requested?
Oh, it was requested at one point in time.
Okay.
And then it was dropped.
Okay.
It ceased to be a matter that needed to be dealt with. It was no longer important. And the evidence of that is that all of the correspondence after the 2016 settlement agreement, but before the litigation began in 2018, which is contained in it's TD 60, it's Exhibit 4 to Mr. Crutcher's deposition. All of that correspondence, which occurred after this request, and now the request is no longer important, demonstrates that the issue was the amount. And I'll just read from the first correspondence, which is July 17, 2017, and the attorneys for Okra.
Well, can you help me out with a kind of threshold question? Is it your position that he was ultimately the $149,000 figure? Was that being awarded under Article 13 for dissolution and termination versus Section 6 point whatever for a departing member? Like which one is operative to come up with $149,000?
Okay, so the $149,000 is actually a number that the appellee came up with and presented to Mr. Crutcher, and he has consistently disputed that. And so what his claim is, there's a couple of different claims. there's a financial interest that's based on the calculation of all of these different accounts, and I've never been provided the accurate information to determine what that is, but there was, to the best of his ability, after he got some documents in 2017, he has made a calculation of what that financial interest is, and that was presented after the summary judgment briefing in plaintiff's calculation of damages. That's TD 81. But the 149 is a number that the appellee came up with, and Mr. Crutcher has never agreed that that was the accurate amount. I think some of it...
Contractually, where does it derive from? Is it Article 13 or Article 6?
I think from appellee's perspective, partially both is how they came up with that math.
Well, what is your position? Which one should he have been awarded?
Both.
Both, okay.
Because our position is that there's a financial interest. So our position is in 2010, and I do want to try to come back. Well, I want to answer your question. In 2010, the agreement, the operating agreement says he was no longer an employee. It does not say he was no longer a member. And if it was going to say he was no longer a member, it would have specifically said when your employment ends, your membership interest ends simultaneously. That's how the contract would have read. Instead, it then separates out the members into remaining members, departing members. There's a departing interest. And our position is that he's a member until he's paid out. And he could have been paid out in a lump sum, but instead he was paid out over time, over 10 years. And because of that, his departing interest was still alive, and he's still a member. And so the financial interest piece is something that would be calculated in 2010, but then it changes over time because of the way these accounts work, and there's this 15% compounding interest. So it's a changing number if it doesn't get paid out in a lump sum.
Just to circle back on
Yes.
your subordination agreement.
Yes.
That was required under section 6.5 of the operating agreement, is my understanding. And so you're saying that the damages that are owed to your client are based on both the 13 and 6. And so your argument on the subordination agreement is not that it didn't apply based on which provision of the operating agreement. It's that that they rescinded the request. That's your argument?
Yes,
Okay.
yes, Your Honor. So I would not concede that it is a material term at all. However, to the extent that it is, it's only a material term if it's requested. And if you look at 6.5, it says the departing member shall execute any subordination agreement requested by any lenders. Well, there was a request, but then that request went away. And I think the evidence of that is very clear. If you read through all of Exhibit 4 to the plaintiff's deposition, it's consistently, the most you are legal, these are the defendant's attorney's words, or appellees in this case, the most you are legally entitled to is, and they've got a calculation, it's not zero, it's not we're asking you to sign a subordination agreement, it's the most you are legally entitled to. That is then followed up with a letter a week later that says, there is no obligation for Okra to pay you anything as long as you dispute the amount that you are owed. And again, the reason the correspondence looks like that, and it never changes, is because the requirement of that agreement being signed, to the extent the request had dropped off. It was no longer important. The debts had been paid at this point. It was no longer important. And actually, there's these other member lawsuits that I think are TD. I don't have the reference to that. It's in one of their footnotes, but it makes reference to the same thing on page 7 of the other member lawsuits, where it says that there was a request for a subordination agreement, and then that request dropped away, and that individual was still willing to engage, but there was discussion over the contents of the subordination agreement, similar to what happened in Mr. Crutcher's case. So Yes, our argument with regard to the subordination agreement is that it just no longer became important, pretty quickly, as a matter of fact. And Mr. Crutcher never refused, and actually there's no time frame. He could still sign one if it was appropriate. I just think that issue's moot at this point. The second issue that I want to cover is Appellant's third assignment of error, and that is the court found that Mr. Crutcher breached the 2016 settlement agreement by suing Dr. Brune and OHC. And I think that is an incorrect determination. If you look at the settlement agreement, which is also, I think, TD 60, and it's Exhibit 21 to Mr. Crutcher's deposition, but the settlement agreement was between Mr. Crutcher and OHC, among others, but not Okra. And there was a specific carve-out that allowed Mr. Crutcher to pursue sums owed from Okra. The court held that he could sue Okra, but not that he could sue Brune. And the court based that finding on the fact that Brune was a releasee, essentially, of OHC. You know, with these settlement agreements, you have OHC is released as well as their shareholders, directors, officers, employees. So Brune was released in connection with his role with OHC. Okay, that makes sense. But he's not released in connection with his role with Okra. If that were the case, then if there any...
Well, but I think this is the problem with a settlement agreement like this, and believe me, I've dealt with many of these when I was in practice.
Yes, Your Honor.
And there's a specific carve-out for claims against the real estate entity, but no one else is included in that. And so when you have these people who wear multiple hats, it's not a impermissible interpretation of this agreement to say, well, he's covered by a release because this is really broad language, and the only carve-out is specific to the LLC and not to someone individually.
Yes, Your Honor. The reason I think it's impermissible is because if you take that to its logical extension, then any role that Mr. Brune had with any other company in town or anywhere, he's been released. If you take that argument to its logical conclusion. And alternatively, then you're looking at, are OHC and Okra really different companies? So that's my interpretation of that, Your Honor. But I do think that release of Mr. Brune under those circumstances is it's not the right result. If you take it to its logical conclusion, then he's released from any role he has with any company anywhere in the world. Then I also want to hit on, I didn't keep track of my time, but I also want to hit on the defendant's second cross assignment of error. I'll be very quick on this. The statements, this is the defamatory, the argument that Mr. Crutcher defamed Brune and OHC by sending some emails and filing a lawsuit. There's an absolute privilege to do what Mr. Crutcher did. All of the statements that appellees are upset about are contained in the lawsuit and or emails just prior to the lawsuit only to Brune and only to his attorneys saying, this is the information I want. I don't think you're dealing with me in good faith. You know, it doesn't get out to any third party. This is exactly what the litigation privilege is meant to protect. And I just don't think that there's an absolute privilege. I did want to cite to some case law. I was looking over the weekend, and because the argument has been made that it applies only to torts, not to contracts. Well, it has been extended to contracts in a number of cases. I'm going to give the court a cite. O'Brien v. City of Salisbury, it's 477 MD 394, 412 through 414, Maryland 2016. And it says, many other jurisdictions have approved the use of the litigation privilege as a defense to claims sounding in breach of contract. And it also says the courts have explained that the privilege would be valueless or meaningless if the opposing party could bar application of the privilege just by drafting the claim in a non-tort label. So I think the privilege is absolute and it extends. And then I also want to hit on the plaintiff appellee's first assignment of error, which is whether the waiver by estoppel doctrine should have been applied.
You've got like a minute left. So.
Okay, I'll be very, very fast, Your Honor. So with regard to the subordination argument, our argument is that, no, he's not entitled to zero, he's entitled to a certain sum. But the court then said it's limited to this 147 because for years he didn't know that it was a different amount. And that's true. For years he did not know that it was a different amount. But he said, I want the information to verify what the correct amount is. And then he didn't start getting that information until 2017. And that's when he said, the information you're giving me shows that the calculations that you've made are clearly wrong. And so I just don't think that the waiver by plus we've got the 15.6 section in the operating agreement, which is a non-waiver clause. And I think that the appellees in this case did not have clean hands because they were the ones who were in charge of giving him the information. And I don't think you can assert an equitable defense of estoppel when you're holding on to the information and the reason why Mr. Crutcher didn't have it or didn't have the accurate calculations is because he was preventing from getting the information that would allow him to make them.
But just
Yes.
so that I understand,
Yeah, sure.
the big issue in this case is one of the big issues is the 15% compounding interest rate.
Yes.
And my understanding from when he was questioned in his deposition is that he did know about that, and that he just decided to go ahead and accept the payments and then deal with that later, not demand the 15% before agreeing to accept the payments. Is that not correct? Or I thought that's part of the waiver argument. Is that I understand there were some issues, like he was trying to get discovery, he was trying to see how much money he was owed ultimately, but he was accepting payment, and
He knew, I'm sorry, Your Honor.
well, no, I mean, he
knew
did
he
know
was
about the 15%.
Yeah, he knew he was owed some amount. I don't think initially that he was relying for a while, and I don't think he initially had thought about that 15%. And then it was only when he started really digging into it in 2016, 2017, after there was this other settlement agreement, that he realized, wait a second, the documents I'm being given seem to prove that you're wrong. And I'm rereading the operating agreement, and there's this 15% compounding. So I think he was relying on them for a number of years. And when he started getting the documents and started really looking back at the issue, that's when he realized how much there really was there.
Okay.
Let me, I'm sorry, I know you're
Yeah, sure.
Go ahead.
time, but it's my understanding that your client received his equity or contributions back when he left. Is that correct? Was it the $176,000, whatever the amount was? Am I correct in that or not?
No, I don't think so. You're
Okay.
right. Go ahead.
Well, the point of my question is that he's saying he didn't really know how much he was owed. But if that was in fact his capital contributions, wouldn't he know that himself? I mean, if he made those capital contributions, he could go back and look at his own records and say, oh, you know what, I put in $500,000.
So that back and forth did occur. He said, look, I don't have the information. And they said, well, look at your K-1s. And he said, I can't find my K-1s. And they wouldn't give them to him.
Okay.
So,
You answered it. Thanks.
Okay.
All right, I'll reserve your
Thank
time
you,
for
Your
rebuttal. Mr. O'Shea, you do have a cross appeal, so you can reserve time if you'd like, or you can use it all at once. Your
I'll
call.
reserve 3 minutes, Your Honor.
Okay, very well.
May it please the court, Mr. Allison, Peter O'Shea on behalf of Appellees, Cross Appellants, Oncology Hematology Care, Inc., OHC Real Estate, LLC, and Dr. Brune. As in the briefing, I'll refer to Oncology Hematology Care as OHC and OHC Real Estate as OCRA. This litigation and most of the assignments of error turn on 3 core disputes. The first is, what was the value of Mr. Crutcher's financial interest in July of 2010 when he was terminated? The second is whether Mr. Crutcher remained a member of OCRA following his termination. And the third is whether Mr. Crutcher violated the subordination agreement violated the single precondition in the operating agreement when he refused to sign the subordination agreement requested by Okra's lender, U.S. Bank.
So let me ask you the same question I asked Mr. Allison. It was the $149,000 calculation, is that based on Article 13 or Article 6?
It starts with Article 6.
Right.
So the value of Mr. Crutcher's financial interest is determined under Section 6. Mm-hmm. Once that amount is determined, it was paid down over 5 years to $91,000 in January of 2016. At that stage, subsequent to the cessation of payments, Okra's members entered a liquidation agreement, and that liquidation agreement is included as an exhibit to Mr. Crutcher's deposition, and that would have superseded Section 13 of Okra's operating agreement. That liquidation agreement put all members as creditors, and so they stood in the same shoes as Mr. Crutcher stood at that time, and all debt was divided pro rata among each of the creditors of Okra.
So I think that just confused me more. Did he sign whatever agreement you're saying superseded Article 13?
Mr. Crutcher did not sign the liquidation agreement. No, he did not. But he was a creditor, and he was treated better than if Section 13 had applied. If Section 13 had applied, Mr. Crutcher would have only been entitled to the $91,000 balance that remained on his financial interest when Okra was liquidated. Instead, he was given the benefit of all former members, and the liquidation proceeds were shared pro rata with him.
Well, and I think that's part of my question, though, is he being treated as a member under Article 13?
He is being treated the same as all the other members who stopped being members. They traded their equity for debt, and at that point, everybody, including all members, were former members, and they were all awarded. They were just creditors, and everybody was treated pro rata. So, frankly, at the end of the day, Your Honor, I don't think that he is benefited, not hurt by that fact. Going back to the first core dispute that I mentioned, the trial court correctly determined that the value of Mr. Crutcher's financial interest was $178,000 as of July of 2010. I want to emphasize that the trial court relied on Mr. Crutcher's affirmative conduct in reaching this. Mr. Crutcher now points to the non-waiver provision that's contained in Section 15.6 of the operating agreement. That non-waiver provision only applies to the failure to act. Here the trial court looked to 7 years worth of affirmative actions. I want to emphasize that Mr. Crutcher was one of the two managers of Okra from 2004 until 2010. That means that he was responsible for maintaining the balance of his financial interest for each year, including the year immediately preceding his departure. So when he left, he was one of the managers who had been maintaining those balances. I also want to emphasize that Mr. Crutcher was litigating against Okra, OHC, and Dr. Brune at the very same time as he was accepting monthly payments. So I think you heard Mr. Allison say that he hadn't been receiving documents to substantiate the value of his financial interest, but he was in litigation against OHC at that time. He had made a claim for the value of his financial interest against OHC at that time, and he conducted discovery into the value of his financial interest at that time.
But by him accepting the payments, you're saying that amounted to a waiver of any other claims that he was owed more?
Accepting 64 payments over 5 years, I think, is sufficient. Okay. But when you accept those 64 payments at the same time as you are litigating the amount, I think collectively that absolutely demonstrates a waiver.
And I think, I guess my question on that was, like, what if it had only been a year or 6 months? Like, is that enough to trigger a waiver by estoppel? Certainly
that's a closer call. That's obviously not what we have here. I think the additional point here is Mr. Crutcher has testified that when he was accepting those payments, he was not blindly accepting them. He knew what they constituted. He knew how they had been calculated. And as Judge Krause pointed out, he knew that had he still been a member, he would have been entitled to 15% compounding interest. And as a result, the payments wouldn't have been fixed at $1,792. Instead, they would have been growing at that time. And he knew that. I think in our briefing, we note that Mr. Crutcher filed 2 motions to compel in the 2010 litigation. In those motions to compel, he never objects to not having sufficient information to establish the value of his financial interest. even though that was a claim. We've also included correspondence, or Mr. Crutcher included correspondence in those motions to compel, back and forth between counsel about whether Mr. Crutcher had sufficient information to calculate the value of his financial interest. That preceded the motion to compel, and then there was no dispute raised in the motion to compel about whether sufficient information was provided. I'm going to turn to the second dispute, which is whether Mr. Crutcher was a member after July of 2010. And this is critical to this issue, to this litigation, because if he was not a member, many of the derivative claims that he's made fall away. If he was not a member, he's not owed a fiduciary duty, for example. And if he's not a member, then his financial interest would not have continued to grow. Mr. Crutcher points to the fact that departing member has the word member in it, and that departing has ing to indicate continuity. As we pointed out in our briefing, departing member is a defined term.
Right, but the problem is member is also a defined term, and it doesn't seem to exclude departing member. And I think that's where I was getting hung up on looking at Article 13, because the member used in that section seems to connote broader than existing members. It seemed to also encompass departing members who are still owed money under the agreement. So how do we reconcile that?
Well, I think if you look at the word, if the definition of member includes departing member and remaining member, the definition of a remaining member is one who continues to be a member. I think the other clarifying...
Well, but the problem is the definition of member says anyone who executes this agreement. So there's no then carve out and says, but once you become a departing member, you are no longer a member.
I take your point, Your Honor. But if you're a departing member, you are required to sell your entire membership interest. So this, I think, is at the end of the day a matter of semantics. If you have no membership interest in OCRA, if you are a 0% owner of OCRA, then you don't have any of the rights and obligations that go along with being a member of OCRA. So even though, again, it's a defined term, but that defined term carries with it certain clarifications that make clear that you are not entitled to any of, again, the rights and obligations of being a member. And I would note that the trial court found Mr. Crutcher's argument on this, in this respect, wholly unpersuasive, and it did so based on the plain language of the operating agreement, but it also noted that Mr. Crutcher's conduct was consistent with the finding that he was not a member. We've already touched on some of it, but in addition, his 2010 K1 showed that he owed 2.8% of OCRA at the beginning of 2010, and at the end of 2010, he owned 0% of OCRA. But these first two issues essentially place a ceiling on what Mr. Crutcher could be entitled to under the operating agreement, the $178,000 as of 2010 and the fact that he was not a member. But the trial court made an error in finding that Mr. Crutcher was entitled to anything, and the reason, as this court has already touched on, is that he refused to sign the subordination agreement requested by...
But do you all have to be harmed by that? Because, like, I can imagine any lender in these circumstances going to say, I want a subordination agreement. Go get it from all of your members. And then what often happens is, like, some people won't sign it. You have issues with that. And so you come back and say, well, I've got 10 signed subordination agreements. I don't have all 15 or whatever the numbers are. And the lender says, okay. Or it might say that, right? Or it might say, no, go get the 5. So what evidence do we have that the failure to execute a subordination agreement actually harmed the company?
Well, first of all, the operating agreement makes it an explicit precondition. Mr. Crutcher was involved, and so we think that the term precondition eliminates this need to look into whether there's some sort of materiality suggestion. I think the harm is what you're seeing right now. There's some question about whether Mr. Crutcher was required or did sign the subordination agreement, and therefore there's some question about whether he's entitled to anything. Mr. Allison said that this issue has simply just kind of fallen away, and it hasn't fallen away. OCRA stopped making payments to Mr. Crutcher in January of 2016 because of this subordination issue. Nevertheless, Mr. Crutcher continued to litigate against OHC, claiming that he was entitled to the value of his financial interest. Had he signed a subordination agreement, there would have been clarity around whether he actually was entitled to any amounts under the operating agreement. I'd also note that...
Did he just refuse to sign it, or was he trying to negotiate the terms of it?
I think both. First, he refused to sign it. He outlined a number of issues. Okra went back to U.S. Bank, and there's evidence in the record that this was U.S. Bank's standard subordination agreement. It wasn't some sort of jerry-rigged document intended to harm Mr. Crutcher. Went back to U.S. Bank. U.S. Bank made modifications to reflect the fact that Mr. Crutcher was in active litigation with OHC, and Mr. Crutcher still refused to sign the subordination agreement. Again, this issue has not fallen away. In the correspondence that is attached as Exhibit 4 to Mr. Crutcher's deposition that Mr. Allison referenced, it's clear that OHC and Okra were always telling Mr. Crutcher that the $147,000 that it was offering is a settlement agreement. And the reason it's a settlement agreement is because OHC and Okra didn't owe it anything, didn't owe Mr. Crutcher anything. That's why this was that's why it was framed as a settlement agreement. I'd like to touch just on a few additional issues, and I think this came up in Mr. Allison's presentation. The trial court correctly dismissed all of the claims against Dr. Brune and OHC as being prohibited by the settlement agreement. Certainly, Mr. Crutcher has made allegations of conduct that occurred after the settlement agreement was executed on December 29 of 2016. But all of those allegations are predicated on pre-December 2016 conduct. They're all predicated on the idea that Mr. Crutcher was owed more than the $178,000 that Okra calculated. They're predicated on the fact that he was still a member. And once you take those factual predicates out, which are again pre-settlement agreement predicates, then at that stage, the derivative claims all fall away. And we've outlined in our brief a number of independent reasons that the derivative claims against Dr. Brune and OHC should also be dismissed, even if the settlement agreement didn't do it. Finally, a word about OHC. The OHC is sued as Okra's alter ego. We cited Minnow v. Profab, which is an Ohio Supreme Court case that makes clear that this horizontal veil piercing is not permitted under Ohio law. So for veil piercing to work, there has to be the parent company has to own some part of the subsidiary, and in this case, there's no dispute that OHC never owned any part of Okra, and that's dispositive of the claim. There's also no support in Ohio law for the idea that alter ego is a standalone claim, that it can stand separate and apart from a piercing the corporate veil. The case law makes clear that piercing the corporate veil requires three elements, the first of which is the alter ego claim, an alter ego test. So if the alter ego test is subsumed within the piercing the corporate veil test, it can't be a standalone claim. And finally, the so-called breach of the so-called non-disparagement claim in the settlement agreement. As we've emphasized, there is a quick scan of the record shows that there are a variety of statements that violated this non-disparagement provision in the settlement agreement. The settlement agreement
were there any statements that were not made in litigation or in communication between counsel?
No, we do not allege. It's all pre-litigation and in litigation. Mr. Allison pointed to a case out of Maryland. There's a variety of cases outside of the state of Ohio that address this issue, but no Ohio case. Thank you.
Thank you. All right, Mr. Allison, you have 3 minutes.
Thank you, Your Honor. I'm going to go quickly through the points here that Mr. O'Shea raised. Mr. O'Shea made the argument that there was affirmative conduct in accepting these payments. It was passive. There was, the conduct in accepting the payments is just simply not, when you're not provided the accurate information.
But what about his point that Mr. Crutcher was effectively the business manager of this entity, so he had access to information prior to his departure? So it's not like he's just some random guy that has no idea what the calculation would be.
Certainly, that is an accurate statement that he would have more access than a random guy. Mm-hmm. But he had not, when he was terminated, reread the operating agreement yet. He did not have his K-1s. And so when he started requesting the information, the other argument that was made was that he was in active litigation. But so often when you're in active litigation and you're asking for information, you're not getting it. there's no dispute that he got information in 2017 for the first time that allowed him to say your calculations are inaccurate, it's a lot more. Even though he was in active litigation for years, he never got that until then.
Couldn't he have refused to accept the payments though, and just said, "Look, I don't know if I agree with this number, so I'm not going to accept the payments until we get this figured out"?
I just don't think it's incumbent upon him to refuse to accept any money because there hasn't yet been agreement on what the total amount is.
Okay.
And that's why.
That's not enough for a waiver.
I don't know, and I don't know that this is in the record, but I'm fairly certain that there was an email from prior counsel that said we're reserving our rights, to determine the accurate amount, but that's years and years and years ago. I'm not sure that it's in this record. And you asked, did he try to negotiate the terms of the subordination agreement? He did. He did not out and out refuse. He said, this is not a subordination agreement. It's got all these other terms, references all these other agreements. There was negotiation, and then that stopped because it no longer became important to U.S. Bank to have one. And that was true in these other member lawsuits. That was TD 62, which is Exhibit 18, references these other member lawsuits where it was the same issue. The request for that subordination agreement just dropped off. It didn't become important anymore. That was about March of 2016. The operating agreement, if you look at section 6.5, it specifically says upon termination of a member's employment with OHC, if his membership interest ultimately terminated at the same time, the operating agreement would have said that. It said your employment terminates, and then here's what we do with your interest. His interest did not terminate at that time. It only terminated after his departing interest was paid out. Could have been immediate, but it was over 10 years. That's all I have, Your Honor. Thank you very much.
Thank you.
One.
All right, Mr. O'Shea, you have 3 minutes.
The record is clear that when Mr. Crutcher sold his entire interest in Okra in exchange for the 10-year payout, OHC's general counsel testified that it's not as though, I believe he said something along the lines of, it's not as though we bought 3% of Mr. Crutcher's interest in exchange for 3% of the payment. Instead, it was a identified debt of $178,000 that was amortized. So again, the principle did not change. This question about what...
But I think this gets back to the question of like why he was paid more than that. And I understand your point, which is like, well, hey, this benefits him. We're paying him more than that under this, I forget which agreement it was that superseded Article 13. But that creates some confusion because if what you just said is accurate, then we would only look at Article 6 and we would say like, okay, you got $91,000. I'm going to write you a check for $91,000. Then you give him more, which seems to feed his point that, like, how do we know?
Well, when we moved for summary judgment, we didn't seek a finding that $147,000 or $149,000 was the correct amount. Instead, our determination was that the financial interest was $178,000, and as of 2010, $91,000 as of January of 2016. And then at trial, we would have had testimony about what took place, what the liquidation provision, what the liquidation agreement required. Instead, the trial court made the determination as to the amount of damages. And frankly, again, we believe that his damages are $0, that he's not entitled to anything because of the subordination issue. We also believe that the appropriate measure of his debt was $91,000. The $147,000 was always proposed as a settlement amount to ensure that we didn't end up in this situation where Mr. Crutcher said, I'm being disadvantaged because I'm treated only as a debtor and not also as a member. Again, in the liquidation agreement, which is, I think it's the final exhibit to Mr. Crutcher's deposition, all of the members of OKRA traded their equity for debt, and so they all became creditors, and that prevented a windfall to the members. Mr. Crutcher was aware before he entered the settlement agreement of this debt equity swap, and he's aware of it because in Exhibit 18 to his deposition, there is a motion for summary judgment in the 2015 litigation. He attached an affidavit and he made reference to the debt equity swap because there was other litigation involving other members related to that. So he was aware of that before the settlement agreement. You mentioned that Mr. Crutcher was maintaining the books and records. Section 5.1 of the operating agreement says that the members of OKRA manage and control the business affairs and properties of OKRA. That was Mr. Crutcher's role from 2004 until 2010. And in 2010, his financial interest was calculated. So he was well aware of the state of OKRA when he left. Finally, he went from $178,000 for his financial interest to $91,000. And then he, as I said in litigation, he admitted it was $178,000. He is now claiming over $5 million. If Mr. Crutcher is entitled to $5 million, that same formula that would get him to $5 million must be applied to all other creditors or all other members, and they would all then be reduced proportionally, right? Each of them should have been treated the same. So to the extent that there was ever any problem with how Mr. Crutcher's financial interest was calculated, that same problem, if it exists, and again, we don't admit that it does, has to be applied to each of the other members, and then everybody comes out the same. Again, as shown in the interrogatory responses, no member or former member of OKRA received in the liquidation any more than $500,000. I see my time is up. Thank you, Your Honor.
Thank you. Thank you both for your arguments this morning. The case will be submitted. We'll get out of time and written decision. Everybody have a great day.